Specific Relief Act, Supreme Court Judgment, AIR 2020, Supreme Court 307, AIR Online 2020 SC6 from Gujarat. Ashok Bhushan and Navin Sinha, Justices. Civil Appeal Numbers 9346 of 2019 and other. Party names: Ambalal Sarabhai Enterprise Limited versus KS Infraspace LLP Limited and another. With Haryana Containers Limited versus KS Infraspace LLP Limited. With Neptune Infraspace Private Limited versus KS Infraspace LLP Limited and another. Specific Relief Act Sections 36-37 discussed. Temporary injunction in suit for specific performance to restrain defendants from executing further sale deed on ground of concluded contract between parties. Existence of concluded contract doubtful and is matter of trial. Failure of plaintiff to demonstrate that parties were ad idem having discharged their obligations. Delay of 7 months in filing suit, though plaintiff was aware that defendant entered into a deal with another purchaser. Grant of injunction unsustainable. Order 39 Rule 1 discussed. Next point. Specific Relief Act, Temporary Injunction. In suit for specific performance is itself a discretionary remedy. Plaintiff has to establish a strong prima facie case on basis of undisputed facts. Conduct of plaintiff is very relevant consideration for purposes of injunction. Discretion has to be exercised judiciously and not arbitrarily. In this judgment, para number 15, 17, 18, 21, 24 are useful for us to remember main points. Para number 15. Chapter 7, Section 36 of the Specific Relief Act provides for grant of preventive relief. Section 37 provides that temporary injunction in a suit shall be regulated by the Code of Civil Procedure. The grant of relief in a suit for specific performance is itself a discretionary remedy. A plaintiff seeking temporary injunction in a suit for specific performance will therefore conduct of the plaintiff will also be a very relevant consideration for purposes of injunction. The discretion at this stage has to be exercised judiciously and not arbitrarily. Para number 17. The negotiations between the plaintiff and the defendant is reflected in approximately 17 emails exchanged between them commencing from December 2017 to 31/3/2018. The file size of the attachment to the mails have varied from 48 to 50, 50 to 48, 57, 56 kbs, indicating suggestions and corrections from time to time. The WhatsApp messages, which are virtual verbal communications or matters of evidence with regard to their meaning and its contents to be proved during trial by evidence in chief and cross-examination. The emails and WhatsApp messages will have to be read and understood cumulatively to decipher whether there was a concluded contract or not. The use of the words final draft in the email dated 30 March 2018 cannot be determined by itself. The email dated 26/2/2018 sent by the defendant at 11:46 am had also used the same phraseology. The plaintiff was well aware from the very inception that the defendant was negotiating for sale of the lands simultaneously with two others. The plaintiff was further aware on 30th March 2018 itself that the deal with it had virtually fallen through as informed to the escrow agent. The fact that a draft MOU christened as final for discussion was sent the same day cannot lead to the inference in isolation of a concluded contract. There is no evidence at this stage that the acceptance was communicated to the defendant before the latter entered into a deal with defendant number 2 on 30th March 2018 and executed a registered agreement for sale on 31st March 2018. Defendant number 2 paid rupees 17.69 crores and rupees 2.20 crores towards the income tax dues of the defendant the same day as part of the consideration amount. It is only thereafter the plaintiff purports to have communicated its acceptance to the defendant on 31st March 2018 at 1:13 p.m. The prolonged negotiations between the parties reflect that matters were still at the embryo stage observed in Agriculture Produce Market Committee, Gondal and another versus Girdhar Bhai, Ramji Bhai, Chaniara and others. 1997 5 SEC 468 and AR 1997 SC 2674. The plaintiff at this stage has failed to establish that there was a mutuality between the parties, much less that they were ad idem. 18th paragraph. The pleadings in the suit acknowledge the awareness of the plaintiff of the ongoing negotiations with defendant number 2. The advance of rupees 2.16 crores was refunded to the plaintiff in the evening on 31st March 2018 by RTGS. No effort was made by the plaintiff to again remit the sum by RTGS immediately or the next day. Only a public notice was published on 3rd April 2018, refuted by the defendant on 4th March 2018. The suit was then filed 7 months later on 1/10/2018. The explanation that the plaintiff waited hopefully for a solution outside litigation. As a prudent businessman, before finally instituting the suit is too lame an excuse to merit any consideration. 21 paragraph. We are therefore of the considered opinion that in the facts and circumstances of the present case and the nature of the materials placed before us at this stage, whether there existed a concluded contract between the parties or not, is itself a matter for trial to be decided on basis of the evidence that may be led. The plaintiff contended a concluded contract and or an oral contract by inference, leaving an executed document as a mere formality. The onus lay on the plaintiff to demonstrate that the parties were ad idem, having discharged their obligations as observed in Bridge Mohan AR Online 1990 SC 83. The plaintiff failed to show the same unadmitted facts. The draft MOU dated 30th March 2018 in Class C contemplated payment of the income tax dues of rupees 18.64 crores. As part of the consideration amount, only way after the agreement was to be signed, relating back to the date 29th March 2008. Had this amount been already paid or remitted by the plaintiff, entirely different considerations would have arisen with regard to the requirement for execution of a written agreement remaining a mere formality. Needless to state, the balance of convenience is in favor of the defendants on account of the intervening developments. Without furthermore, inter alia, by reason of the plaintiff having waited for 7 months to institute the suit, The question of irreparable harm to a party complaining of a breach of contract does not arise if other remedies are available to the party complaining of the breach. The High Court has itself observed that from the negotiations between the parties that some rough weather was being reflected between the plaintiff and the defendant. The special civil judge failed to address the issue of the delay. 24. The High Court noticed the arguments of the defendant with regard to delay in the institution of the suit, but failed to of the present deal with it. The grant of injunction to the plaintiff is unsustainable. Resultantly, the orders of injunction are set aside. Nothing in the present order shall be deemed or considered as any expression of opinion or observation by us at the final hearing of the suit, which naturally will have to be decided on its own merits. The High Court has already given directions to expedite the hearing of the suit, and we reiterate the same. The appeals are allowed.